I have been inspired by the founding fathers of our constitution that I should discuss about the nature of the constitution. Nature of the constitution first starts from utility of a historical retrospect. The very fact of the Constitution of the Indian Republic is the product not of a political revolution but of the research and deliberations of a body of eminent representatives of the people who sought to improve upon the existing system of administration. Makes a retrospect of the constitutional development indispensable for a proper understanding of this constitution. Practically, the only respect for in which the Constitution of 1949 differs from the constitutional documents of the preceding 2 centuries is that while the latter had been imposed by an imperial power, the Republican Constitution was made by the people themselves through representatives assembled in a sovereign constituent assembly. That explains the majesty of the ethical values of a new instrument and also the significance of those of its provisions which have been engrafted upon the pre-existing system. Now I am discussing about Government of India Act 1858. For our present purposes, we need not to go beyond the year 1858 when the British Crown assumed sovereignty over India from the East India Company. The Parliament enacted the first statute for the governance of India under the direct rule of the British government. The Government of India Act 1858, 21 and 22 BICT C 106. This act serves as the starting point of our survey because it was dominated by the principle of absolute imperial control without any popular participation in the administration of the country. While the subsequent history up to the making of the constitution is one of gradual relaxation of imperial control and the evolution of responsible government. By this act, the powers of the crown were to be exercised by the Secretary of State for India, assisted by the Council of 15 members known as the Council of India. The council was composed exclusively of people from England, some of whom were nominees of the Crown, while others were the representatives of the directors of the East India Company. The Secretary of State, who was responsible for the British Parliament, governed India through the Governor General, assisted by an Executive Council which consisted of high officials of the government. The essential features of the system introduced by the Act of 1858 where the administration of the country was not only unitary but rigidly centralized. Though the territory was divided into provinces with a governor or lieutenant governor added by his executive council at the head of each of them, the provincial government were mere agents of the Government of India and had to function under the superintendence, direction and control of the Governor General in all matters relating to the government of the province. B. There was no separation of functions and all the authority for the governance of India, civil and military, executive and legislative, was vested to the Governor General in Council, who was responsible to the Secretary of State. The control of the Secretary of State over the Indian administration was absolute. The Act vested in him the superintendence, direction and control of all acts, operation and concerns which in any way related to the government or revenues of India. Subject to his ultimate responsibility to the British Parliament, he wielded the Indian administration through the Governor General as his agent, and his was the last word, whether in matters of policy or in details. The entire machinery of administration was bureaucratic, totally unconcerned about public opinion in India. The Indian Council Act of, now I am discussing about Indian Council Act 1861. The Indian Council Act of 1861 introduced a grain of popular element in so far as it provided that the Governor General's Executive Council, which was so long composed exclusively of officials, should include certain additional non-official member while transacting legislative business as a legislative council, but this legislative council was neither representative nor deliberative in any sense. The members were nominated and their functions were confined exclusively to a consideration of the legislative proposals placed before it by the Governor General. It could not in any manner criticize the acts of the administration or to conduct of authorities. Even in legislation, effective powers were reversed to the Governor General, such as giving prior sanction to bills relating to certain matters, without which they could not be introduced in the Legislative Council, vetoing the bills after they were passed or reserving them for consideration of the Crown, legislating by ordinances which were to have the same authority as acts made by the Legislative Council. Similar provisions were made by the Act in 1861 for legislative councils in the provinces, but even for initiating legislation in these provincial councils with respect to many matters, the prior sanction of the Governor General was necessary. Now I am talking about Indian Council Act 1892. Two improvements upon the preceding state of affairs as regards the Indian and provincial legislative councils were introduced by the Indian Council Act 1892, namely that a, though the majority of the official members were retained, a non-majority of official members were retained. The non-official members of the Indian Legislative Council were henceforth to be nominated by the Bengal Chamber of Commerce and the provincial legislative councils, while the non-official members of the provincial councils were to be nominated by certain local bodies such as universities, district boards, municipalities. B, the councils were to have the power of discussing the annual statement of revenue and expenditure, that is the budget, and addressing questions to the executive. This act is notable for its object, which was explained by the Under Secretary of State for India thus: to widen the basis and expand the functions of the Government of India, and to give further opportunities to the non-official and native elements in Indian society to take part in the work of the government. Now I am talking about Morley-Minto reform and the Indian Councils Act 1909. The first attempt at introducing a representative and popular element was made by the Morley-Minto reforms, known by the name of then Secretary of State for India Lord Morley and the Viceroy Lord Minto, which were implemented by the Indian Council Acts 1909. The changes relating to the provincial legislative councils were, of course, more advanced. The size of these councils were enlarged by the including elected non-official members, so that the official majority was gone. An element of election was also introduced in the legislative council at the center, but the official majority there was maintained. The deliberative function of the legislative councils were also increased by this act by giving them the opportunity of influencing the policy of the administration by moving resolutions to the budget and on any matter of public interest, save certain specified subjects such as the armed forces, foreign affairs, and Indian states. On the other hand, the positive vice of the system of election introduced by the Act of 1909 was that it provided for the first time for separate representation of Muslim community and thus sowed the seeds of separatism that eventually led to the lamentable partition of the country. It can hardly be overlooked that this idea of separate electorates for the Muslim were synchronous with the formation of Muslim League as a political party in 1906. Subsequent to this, the Government of India Act 1915, 5 and 6 GOV C 61 was passed merely to consolidate all the preceding governments of India Act so that the existing provincial relating to the Government of India in its executive, legislative and judicial branches could be hived from one enactment. Now I am talking about Montagu-Chelmsford Report and the Government of India Act 1909. The next landmark in constitutional development in India is the Montagu-Chelmsford Report, which led to the enactment of the Government of India Act 1919. It was in fact the amending act, but the amendments introduced substantive changes into the existing system. The Morlow-Minto reform failed to satisfy the aspirations of the nationalists in India, in as much as professedly the reforms did not aim at the establishment of the parliamentary system of government in the country and provide for the retention of the final decision on all questions in the hands of the irresponsible executive. The Indian National Congress, which established in 1885, was so long under the control of moderates, became more active during the First World War and started its campaign for self-government known as the Home Rule movement. In response to this popular demand, the British government made a declaration on August 20, 1917 that the policy of His Majesty's government was that of increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to progressive realization of responsible government in British India as an integral part of the British Empire. The then Secretary of State for India, Mr. E.S. Montagu, and the Governor General Lord Chelmsford, entrusted with the task of formulating proposals for carrying out the above policy, and the Government of India Act 1919 gave a legal shape to their recommendations. Main features of the system introduced by the Act of 1919, the main features of the system introduced by the Government of India Act 1919 were as follows. Diarchy in the provinces, responsible government in the provinces was sought to be introduced without impairing the responsibility of the governor through the Governor General for the administration of the province by resorting to device known as diarchy or dual government. The subjects of administration were to be divided by rules made under the Act into two categories, central and provincial. The central subjects were those which were exclusively kept under the control of the central government. The provincial subjects were subdivided into transferred and reserved subjects. Of the matters assigned to the provinces, the transferred subjects were to be administered by the governor with the aid of ministers responsible to legislative council, in which the proportion of elected members was raised to 70%. The foundation of responsible government was thus laid down in the narrow sphere of transferred subjects. The reserved subjects, on the other hand, were to be administered by the governor and executive council without any responsibility to the legislature. Second, relaxation of central control over the provinces. As stated already, the rules made under the Government of India Act 1919, known as the devolution rules, made a separation of the subjects of administration into two categories, central and provincial. Broadly speaking, subjects of all India importance were brought under the category central, while matters primarily relating to the administration of the provinces were classified as provincial. This meant a relaxation of the previous central control over the provinces, not only in administrative but also in legislative and financial matters. Even Even the sources of revenue were divided into two categories so that the provinces could run the administration with the aid of revenue raised by the provinces themselves, and for this purpose the provincial budgets were separated from the government of India, and the provincial legislature was empowered to present its own budget and levy its own taxes relating to the provincial sources of revenue. At the same time, this devolution of power to the provinces should not be mistaken for a federal distribution of powers. Under the Act of 1919, the provinces got power by way of delegation from the center. The central legislature therefore retained power to legislate for the whole of India relating to any subject, and it was subject to such paramount power of central legislature that the provincial legislature got the power to make laws for the peace and good government of the territories for the time being constituting that province. The control and of the Governor General over provincial legislation was also retained by the laying down that the provincial bill, even though assented to by the governor, would not become law unless assented to also by the Governor General, and by empowering the government to reserve a bill for the consideration of the Governor General if it related to matters specified in this behalf by the rules made under the Act. Third, the Indian legislature made more representative. No responsibility was, however, introduced at the center, and the Governor General in Council continued to remain responsible only to the British Parliament through the Secretary of State for India. Nevertheless, the Indian legislature was made more representative and for the first time bicameral. It was to consist of an upper house named as the Council of States, composed of 60 members, of whom 34 were elected, and a lower house named Legislative Assembly, composed of about 144 members, of whom 104 were elected. The powers of both of the houses were equal, except that the power to vote supply was given exclusively by the Legislative Assembly. The electorates were, however, arranged on a communal and sectional basis, developing the Morley-Minto device further. The Governor General's overriding power in respect of the central legislation were retained in the following forms. His prior sanction was required to introduce bill relating to the certain matters. He had the power to veto or reserve for consideration of the Crown by bill passed by the Indian legislature. He had the converse power of certifying any bill or any grant refused to be passed or made by the legislature, in which case it would have the same effect as if it was passed or made by the legislature. He could not make ordinances having the force of law for the temporary period in case of emergency. At the historical background of Indian Constitution के संदर्भ में मैं आपको जो ही बातें आपके सामने ला रहा हूँ वो एक बहुत बड़े लेखक थे, उनके किताब से लेकर मैं आ रहा हूँ, उनकी लिखी पुस्तक से लेकर मैं आ रहा हूँ. द रिफॉर्म ऑफ 1919 however failed to fulfill the aspiration of people in India and led to an agitation by the Congress then under the leadership of Mahatma Gandhi for Swaraj or self-government independent of the British Empire to be attained through non-cooperation. The shortcomings of the 1919 system mainly were, notwithstanding a substantial measure of devolution of power to the provinces, and the structure still remained unitary and centralized, with the Governor General in Council as the keystone of the whole constitutional edifice. And it is through the Governor General in Council that the Secretary of State and ultimately Parliament discharge their responsibilities for the peace. Order and good government of India. It was the Governor General and not the courts who had the authority to decide whether a particular subject was central or provincial. The provincial legislature could not, without the previous sanction of the Governor General, take up for consideration any bill relating to a number of subjects. Second, the greatest dissatisfaction came from the working of diarchy in provincial sphere. In a large measure, the governor came to dominate ministerial policy by means of his overriding financial powers and control over the official bloc in the legislature. In practice, scarcely any question of importance could arise without affecting one or more of the reserved departments. The impracticability of the division of the administration into two watertight compartments were manifested beyond doubts. The main defect of the system from the Indian standpoint was the control of the purse. Finance, being a reserved subject, was placed in charge of a member of the Executive Council and not the minister. It was impossible for any minister to implement any progressive measure for want of funds, and together with this was the further fact that the members of the Indian civil service, whom the ministers were to implement their policies, were recruited by the Secretary of State and were responsible to him and not to the ministers. Above all was the overriding power of the governor, who did not act as a constitutional head even with respect to the transferred subjects. There was no provision for collective responsibility of the ministers to the provincial legislature. The ministers were appointed individually, acted as advisors of the governor, and differed from members of the Executive Council only in fact that they were non-officials. The governor has the discretion to act otherwise than in accordance with the advice of his ministers. He could certify a grant refused by the legislature or a bill rejected by it if it was regarded by him as essential for the due discharge of his responsibilities relating to a reserved subject. It is no wonder, therefore, that the introduction of ministerial government over a part of the provincial sphere proved ineffective and failed to satisfy Indian aspirations. The persistent demand for further reforms, attended with the dislocation caused by the non-cooperation movement, led the British government in 1927 to appoint a statutory commission as envisaged by the Government of India Act 1919 itself. Section 84A, to inquire into the report on working of the Act, and in 1929 to announce the Dominion status was the goal of Indian political developments. The commission, headed by Sir John Simon, reported in 1930. The report was considered by a round-table conference consisting of the delegates of British government of British India as well as of the rulers of the Indian states. Inasmuch as the scheme was to unite the Indian states with the rest of the India under a federal scheme, a white paper prepared on the results of this conference was examined by a joint select committee of the British Parliament, and the Government of India bill was drafted in accordance with the recommendation of the select committee and passed with certain amendments as the Government of India Act 1935. Now, communal award. Before analyzing the main features of the system introduced by this act, it should be pointed out that this act went another step forward in preparing the communal cleavage between the Muslim and non-Muslim communities by prescribing separate electorate on the basis of the communal award, which was issued by Mr. Ramsay MacDonald, the British Prime Minister, on August 4, 1932, on the ground that the two major communities had failed to come to an agreement. From now onwards, the agreement between the two religious communities was continuously hoisted as a condition precedent for any further political advance. The Act of 1935, it should be noted, provided separate representation not only for the Muslims but also for the Sikhs, the Europeans, Indian Christians, and Anglo-Indians, and thus created a serious hurdle in the way of building up of national unity, which the makers of the future constitution found it almost insurmountable to overcome even after the Muslims had partitioned for the separate state. The main features of governmental system prescribed by the Act of 1935 were as follows: federation and provincial autonomy. While under all the previous Government of India Acts, the Government of India was unitary, the Act of 1935 prescribed a federation taking the provisions of the Indian states as units, but it was optional for the Indian states to join the federation. And since the rulers of the Indian states never gave their consent, the federation envisaged by the Act of 1935 never came into being. But though the part relating to the federation never took effect, the part relating to provincial autonomy was given effect to since April 1937. The Act divided legislative powers between the provincial and central legislatures, and within its defined sphere, the provinces were no longer delegates of the central government but were autonomous units of administration. To this extent, the Government of India assumed the role of the federal government vis-a-vis the provincial government, though the Indian states did not come into the fold to complete the scheme of federation. The executive authority of the province was also exercised by a governor on behalf of the crown and not as a subordinate of the governor general. The governor was required to act with the advice of ministers responsible to the legislature. But notwithstanding the introduction of provincial autonomy, the Act of 1935 retained control of the central government over the provinces in a certain sphere by requiring the governor to act in his discretion or in the exercise of his individual judgment in certain matters. In such matters, the governor was to act without ministerial advice and under the control and directions of the Governor General, and though him of the Secretary of State. Diarchy at the center. The executive authority of the center was vested in the Governor General on behalf of the Crown, whose functions were divided into two groups: the administration of defense, external affairs, ecclesiastical affairs, and the tribal areas was to be made by the Governor General in his discretion with the help of councillors appointed by him, who were not responsible to the legislature. With regard to the matters other than the above reserved subjects, the Governor General was to act on the advice of Council of Ministers, who were responsible to the legislature. But even in regard to this latter sphere, the Governor General might act contrary to the advice so tendered by the ministers if any of his special responsibilities was involved. As regards the special responsibilities, the Governor General was to act under the control and discretion of the Secretary of State. But in fact, neither any councillors nor any Council of Ministers responsible to the legislature came to be appointed under the Act of 1935. The old Executive Council provided by the Act of 1919 continued to advise the Governor General until the Indian Independence Act 1947. The legislature, the central legislative, was bicameral, consisting of Federal Assembly and Council of States. In 6 of the provinces, the legislature was bicameral, comprising a legislative assembly and the legislative council. In the rest of the provinces, the legislature was unicameral. The legislative power of both the central and provincial legislatures was subject to various limitations, and neither could be said to have possessed the features of the sovereign legislature. Thus, the central legislature was subject to the following limitations. Apart from the Governor General's power to veto, a bill passed by the central legislature was also subject to veto by the Crown. The Governor General might prevent discussion in the legislature and suspend the proceedings in regard to any bill if he was satisfied that it would affect the discharge of his special responsibilities. Apart from the power to promulgate ordinances during the recess of the legislature, the Governor General had independent powers of legislation concurrently with those of the legislature. Thus, he had the power to make temporary ordinances as well as permanent acts at any time for the discharge of his special responsibilities. No bill or amendment could be introduced in the legislature without the Governor General's previous sanction with respect to the certain matters. As example, if the bill or amendment sought to repeal or amend or was repugnant to any law of the British Parliament extending to India or any Governor General's or Governor's Act, or if it sought to effect matter as respects with which the Governor General was required to act in his discretion. There were similar letters on the provincial legislature. The instruments of instructions issued under the Act further required that bills relating to a number of subjects, such as those derogating from the powers of the High Court or affecting the permanent settlement, when presented to the Governor General or a governor for his assent, were to be reserved for the consideration of the Crown or the Governor General, as the case might be. Distribution of legislative powers between the center and the provinces. Though the Indian states did not join the federation, the federal provision of the Government of India Act 1935 were in fact applied as between the central government and the provinces. The division of legislative powers between the center and the provinces is of special interest to the reader in view of the fact that the division made in the Constitution between the Union and the states proceeds largely on the same lines. It was not a mere delegation of powers by the center to the provinces as by rules made under the Government of India Act 1919. As already pointed out, the Government of India Act of 1935 itself divided the legislative powers between the central and provincial legislatures, and subject to the provision mentioned below, neither legislature could transgress the power assigned to the other. A threefold division was made in the Act. There was a federal list over which the federal legislature had exclusive powers of legislation. This list included matters such as external affairs, currency and coinage, naval military and air forces, census. Second, there was a provincial list of matters over which the provincial legislature and the executive jurisdictions, as for example, police, provincial public service, education. There was a concurrent list of matters over which both the federal and the provincial legislature had competence, as for example, criminal law and procedure, civil procedure, marriage and divorce, arbitration. The federal legislature has the power to legislate with respect to matters enumerated in the provincial list of the proclamation of emergency was made by the Governor General. The federal legislature could also legislate with respect to a provincial subject if the legislature of two or more provinces desired this in their common interest. In case of repugnancy in the concurrent field, a federal law prevailed over the provincial law to the extent of the repugnancy. But if the provincial law, having been reserved for the consideration of the Governor General, received his assent, the provincial law prevailed notwithstanding such repugnancy. The allocation of residuary power of legislation in the Act was unique. It was not vested in either the central or the provincial legislature, but the Governor General was empowered to authorize either the federal or the provincial legislature to enact a law with respect to any matter which was not enumerated in the legislative list. It is to be noted that dominion status, which was promised by the Simon Commission in 1929, was not conferred by the Government of India Act 1935. The circumstances leading to the enactment of the Indian Independence Act 1947 will be explained in the next chapter, but the changes introduced by this act into the structure of government pending the drawing up of the Constitution for Independent India by Constituent Assembly should be pointed out in the present context so as to offer a correct and comprehensive picture of the background against which the Constitution was made. In pursuance of the Indian Independence Act, the Government of India Act 1935 was amended by the adaptation order both in India and Pakistan in order to provide an interim constitution to each of the two dominions until the Constituent Assembly could draw up the future constitution. The following were the main results of such adaptations: abolition of the sovereignty and responsibility of the British Parliament, as has been already explained by the Government of India Act 1858. The Government of India was transferred from the East India Company to the Crown. By this act, the British Parliament became the direct guardian of India, and the office of the Secretary of State of India was created for the administration of Indian affairs, for which the Secretary of State was to be responsible to Parliament. Notwithstanding gradual relaxation of the control, the Governor General of India and the provincial governors remained substantially under the direct control of the Secretary of State until the Indian Independence Act 1947, so that in constitutional theory, the Government of India is a subordinate official government under His Majesty's government. The Indian Independence Act altered this constitutional position root and branch. It declared that with effect from the 15th August 1947, referred to as the appointed day, India ceased to be a dependency and the suzerainty of the British Crown over the Indian states, and the treaty relations with tribal areas also lapsed from the date. The responsibility of the British government and Parliament for administration of India having ceased, the office of the Secretary of State for India was abolished. The Crown no longer the source of authority so long as India remained a dependency of the British Crown. The Government of India was carried on in the name of His Majesty. Under the Act of 1935, the Crown came into further prominence owing to the scheme of the Act being federal, and all the units of the Federation, including the provinces, drew their authority direct from the Crown. But under the Independence Act 1947, neither of the two dominions of India and Pakistan derived its authority from the British Isles. The Governor General and provincial governors to act as constitutional head. The Governor General of the two dominions became the constitutional heads of the two new dominions, as in the case of the other dominions. This was in fact a necessary corollary for dominion status, which had been denied to India by the Government of India Act 1935 but conceded by the Indian Independence Act 1947. According to the adaptations under the Independence Act, there was no longer any executive council as under the Act of 1919 or councillors as envisaged by the Act of 1935. The Governor General or the provincial governor was to act on the advice of the Council of Ministers, having the confidence of the Dominion legislature or the provincial legislature. As the case might be, the word in his discretion, acting in his discretion, and individual judgment were affected from the Government of India Act 1935. Wherever they occurred, with the result that there was no sphere in which these constitutional heads could act without or against the wishes of the ministers. Similarly, the power of the Governor General to require governors to discharge their certain functions as his agents were deleted from the Act. The Governor General and the governors lost extraordinary powers of legislation so as to compete with the legislature by passing acts, proclamations, and ordinances ordinances for ordinary legislative purposes, and also the power of certification. The governor's power to suspend the provincial constitution was taken away. The crown also lost its right of veto, and so the governor general could not reserve any bill for the signification of his majesty's pleasure. Sovereignty of dominion legislature. The central government of India, composed of the legislative assembly and council of states, ceased to exist on August 14, 1947 from the appointed day, and until the constituent assemblies of the two dominions were able to frame their new constitutions and new legislatures were constituted thereunder. It was the constituent assembly itself which was to function also as the central legislature of the dominion to which it belonged. In other words, the constituent assembly of either dominion, until it itself desired otherwise, was to have a dual function, constituent as well as legislative. The sovereignty of the dominion legislature was complete, and no sanction of the governor general would henceforth be required to legislate on any matter, and there was to be no repugnancy by reason of contravention of any imperial law. This is all about the history of the making of our constitution and constitutional background. Thanks, regards.